You each will have 15 minutes, you can reserve up to 5 if you want. Just
Sounds
let me
good.
know.
Sure. May it please the court, my name is Attorney Michael Stepanek. On behalf of my client and defendant Helen Albert Ross III, I'd like to reserve about 4 minutes for rebuttal if I can. Mr. Ross is driving north on 71, gets pulled over by the police, for speeding, I suppose. Police officer runs his name for warrants, clear, wants to make sure he has a valid license. He does. He's going to issue him a warning. Officer says it takes me between 7 to 8 minutes from beginning the process of running all my checks until I actually fill out a warning. At 7 and 8 minutes had elapsed. The officer waits, and he waits, and he waits, and he waits. He waits at least, from the testimony at the motion to suppress hearing, 12 to 13 minutes until a canine officer eventually shows up. How long it takes that canine officer to do what it has to do to alert, don't know. There was no testimony garnered by the state as to how long or how reasonable that period of time took. So I think that this leads to two different assignments of error. First being that Mr. Ross was unconstitutionally detained for the police to come and get a canine, and the second is that there was an unlawful search of a protected area of his vehicle that even with the introduction of the canine does not establish probable cause for that search. The first issue, there's a case, United States versus Rodriguez came out last year and said, look, we're not going to anymore say, well, someone was only left, by the side of the road for 2, 3, 4, 5 minutes longer than the officer's, traffic mission. So that's reasonable. That's what the government attempted to argue in the United States Supreme Court last year. The United States Supreme Court said, no, we're done with this. What we're going to do now is we're going to say, what did the police actually do? Not whether it was reasonable for them to keep a citizen far, further beyond the time than they were required to or needed to or were allowed to, but we're going to focus on what the police actually did. And in this case, the officer said that he was going to offer or issue Mr. Ross a written warning. He said from start to finish, it takes 7 to 8 minutes. And then he just waited, and he waited, and he waited, and he waited. So at that point in time, I think his traffic mission, his stated reason for pulling Mr. Ross over speeding, he had satisfied himself that he was just going to issue a warning, but didn't have an officer there. So he waited. And we don't
did
really
he testify that during that time he wasn't doing any, checking the computer for warrants or checking his driving record or anything like that?
He said it takes him, in this point in time, 7 to 8 minutes to do that. So yeah, that includes all of that. I think at the transcript at pages 32 to 33, I believe, the time of the stop was 1:18. Brunswick arrived 20 minutes later. And then on page 33 into 34, how long does it take to fill out the paperwork and run his license for wants and warrants, all that, and he says it could be done in 7 to 8 minutes. So he testified that that's what time it took him.
And there seemed to be some discrepancy in terms of what the trial court found.
Correct.
As to how long after the stop
Correct.
the canine unit arrived.
Right, and I think that I had addressed that, albeit in a footnote in my brief. The trial court says that Officer Kohler testified that 7 to 8 minutes elapsed while waiting for the dog to arrive. That's nowhere in any of the transcripts. I mean, if the state has that, then God bless it, it could bring it up, but it's not there. I believe that Officer Kohler advised the 7 to 8 minutes was the time it took him to perform the background and license checks as well as to fill out a warning. It took 20 minutes for the initial time for the canine to arrive. That's the transcript at 32 through 34. So I believe that the trial court was maybe mistaken in its what the 7 to 8 minutes meant, and then I think is supported by the transcript. So well, the reason why the officer waited, I don't know that the officer is certain why he waited. He was asked by the state's attorney at the hearing, well, why did you wait? Why did you not give him the warning? And he said, one was he was waiting for the canine officer to arrive. Well, usually when you start to list things, one, he never gets to two, but he says, one, I was waiting for the canine officer to arrive. So I'm not really certain that the smell of burnt marijuana gives you unlimited amount of time to wait for a canine officer to arrive. I think that State versus Ferris is pretty clear that you're limited to a search of the interior compartment. Now, could the officer have searched the interior compartment of the car? Sure, probably. Did he? No. And I think that's why United States versus Rodriguez is so important, because they want to focus on what the police actually did. And what they actually did was wait. Now, if the court were to uphold, if this court were to uphold the trial court's decision in this, then that would basically mean, my opinion, that if you smell burnt marijuana, you can hold a citizen at the side of the road for as long as it takes to get a canine officer there. And in this particular case, what's kind of, I don't want to say scary, but kind of dumb, is that the canine can smell burnt marijuana. The officer testified, this canine can smell burnt marijuana. So I'm a human being, I can't go into the trunk at all because I'm limited, because my olfactory sense ain't quite as impressive as a canine's. But let me call the canine that I know for an absolute fact will smell the same thing that I can smell, but it's a super special smell. So, and because we cannot communicate with the canine, and the officer even says, the canine handler, look, I have no idea what my dog alerted to. He can't tell me if it's cocaine, heroin, raw burnt marijuana. I just know I can search the car. I'm sure the officers love doing this. Hey, I can't search the trunk. Get a canine out here. That's all you got to do. State versus Ferris no longer exists.
I thought I understood you to say in your merit brief that the officer, once the officer smelled burnt marijuana and had the conversation with the driver about whether there were people smoking in the car recently, that he had not reasonable suspicion but probable cause to search. Is that right?
No, I believe that Mr. Ross does at some point in time, and I want to say it was after the canine search, says, my friends were smoking marijuana earlier in my car. Mm-hmm. So I think at that point in time, maybe even regardless of when Mr. Ross told the officer that would give the officer the ability to search the interior compartment of the car. Had he searched the interior compartment of the car, he would have not come up with anything that was found in the trunk, because his search would have been limited.
He would have come up with the marijuana shake.
A little bit of shake, which may have been a minor misdemeanor. I don't even believe that the police officers collected that as evidence. He wasn't cited for that or anything like that. I don't even believe that they knew, they didn't seize it for purposes of getting a lab report or anything like that. So I think that's, that brings me into the second assignment of error, which is, in order for, I guess these kind of blend together, so to speak, because with the first, that Mr. Ross was held longer, the police officer says it's going to take me 7 to 8 minutes. How long would it have taken him to then conduct a search of the interior compartment of the car? We don't know. He was never asked, and we believe it's the state's burden to prove the reasonableness of the search.
Let me stop you.
Sure.
Because I found what I remembered having read, and that is the first paragraph under your second assignment of error. You cite State v. Ferris.
Correct.
That's at the top of page 6, for the proposition that the Supreme Court said probable cause determinations are different for the passenger compartment of the vehicle as opposed to the trunk. Then you say, noteworthy is the fact that Deputy Kohler, armed with probable cause to search the interior compartment of the vehicle, failed to do so. Correct.
Yes, I do believe that the smell of burnt marijuana, and Deputy Kohler does not at any point in time, he never said, I didn't smell raw or burnt marijuana until the canine got there. Right. He smelled, I believe, and I would concede, he had probable cause to search the interior compartment of the car. He didn't do so. And the reason he didn't do so, he testified, was because he was waiting for the canine to get there. And that was on direct examination. He says he was waiting for the canine to get there. Well, again, once the canine got there, this I think what kind of flows into the second assignment of error, the canine smells exactly what the officer smells, can't make any distinction. Aha, now we're in the trunk. State versus Ferris no longer exists.
And you're saying the canine smell.
I don't know what
It's
the.
silly for me to say this.
Right.
But you're saying the canine smelled what he smelled, though, based on the officer testifying that he smelled the burnt marijuana.
I don't know what the canine smelled.
No, I know that.
Right. Well, and I think that.
I'm asking the testimony, you're basing that conclusion on the testimony that was offered at the suppression hearing.
Where the officer says that the dog, if it alerts, will alert to a substance, will not be able to distinguish between burnt and raw marijuana. So yes, it's very possible. So I guess we're looking at probable cause and what's the likelihood that something happened. Well, there were no other drugs found anywhere in the car. The canine hit, for lack of a better term, I like that term, on the front of the car, which you talk to an officer, well, that doesn't necessarily mean anything. A hit is a hit, I suppose. But what was found, or I suppose the passenger compartment of the car, the front of the car, is where someone was smoking doobs. And then eventually they get to the car and they say, hey, let's look in the trunk because we don't find anything here. And they smell, or, they find raw marijuana, which they never could have gotten to beforehand.
You're at 4 minutes if you want to.
And I'm going to sit down and wait
Thank you.
before.
Good morning again. My name is Matthew Curran on behalf of Dean Holman, the Medina County Prosecuting Attorney representing the state of Ohio in this matter. Here, please report. This is an interesting case, and the argument this morning by Mr. Stepanek, the recitation of facts he gave you in the first minute and a half, 2 minutes of his argument left out a very important fact that the court eventually identified, is that the officer, when he made his approach to the vehicle, immediately upon making his approach on the passenger side of the vehicle, smelled the odor of burnt marijuana. That observation gave him not only reasonable suspicion to extend the duration of the stop, but also probable cause to eventually conduct a search of the passenger compartment. Now, I know that ultimately this case will be important for the sense of in what situations does Ferris apply and in what situations do this court's decisions in State versus Valenti, the 9th District Summit County decision, 2013 Ohio 5564, where at paragraph 15, this court specifically held if an officer can point to reasonable, articulable reasons for his suspicion, that he can extend the length and scope of the detention, specifically to wait for a canine for a reasonable period of time to arrive at the scene. That is exactly opposite what Mr. Ross is contending should happen in this case. His contention is that, well, the 7 to 8 minutes to run for wants and warrants versus the 20 minutes it took from the time of the stop beginning to when the dog arrived and he started its sniff, well, that's unreasonable. No, State versus Valenti, this court held that it is reasonable if the officer has reasonable, articulable reasons that he is suspicious and wants the canine to come, and he can extend the duration of the stop for a reasonable period of time to wait for that canine to come to conduct its sniff. That's precedent. You would have to overrule Valenti to adopt the appellant's position in this case. He next points to Rodriguez, 2015 U.S. Supreme Court case. Rodriguez is different on its facts. In Rodriguez, police in Iowa, I believe, testified very specifically under an 8th Circuit rule that existed, which was an aberration, admittedly, that they had finished conducting their check for wants and warrants, they had finished writing the citation, and under 8th Circuit precedent, as long as they did so expediently, they got essentially bonus time in which to conduct any other investigative methods they wanted. That's why Rodriguez fails. Rodriguez does not reverse long-standing Fourth Amendment law that as long as you are doing your wants and warrants checks, you're writing the citation, if a canine arrives in that period of time, it does not change that law. You can still have the canine suspicionless. If a canine arrives at the scene while those wants and warrants are being run, while the citation is being written in due diligence, running them in the course, if a second officer shows up with a dog, you can have the dog conduct its sniff. Rodriguez doesn't change that. Rodriguez very specifically, I think it's even page 1615 of the Rodriguez decision, I'm using the Supreme Court reporter, not the U.S. reporter, it specifically left out situations where the officer has reasonable articulable suspicion to extend the stop. Rodriguez is not to the contrary, as the appellant would have you believe. It specifically omitted and left intact all of its previous decisions, specifically authorizing the police course of conduct in this case. Those cases are cited in the state's brief. You can have a dog show up to a scene of a traffic stop without interfering with the initial traffic mission of the stop. As long as the traffic stop is being conducted in a diligent manner, that's okay. In this case then, the interaction between Ferris, the burnt marijuana search of a passenger compartment of the vehicle, and this court's previous decision in State v. Reed, a Lorain County case, 2013 Ohio 4274, Reed already addressed the interaction between Ferris and the dog sniff, which is a search of the entire vehicle. It held that where an officer would otherwise be justified in a search under Ferris, but a dog then alerts and would otherwise provide probable cause to search the entire vehicle, the dog's alert controls. Police are entitled to conduct a search of the entire vehicle. Now the issue, and I understand Mr. Stepanek raises today, is, well, if the officer already smelled burnt marijuana and the dog is also capable of detecting the odor of burnt marijuana, well, isn't it possible that the dog is only alerting to burnt marijuana? Admittedly, yes. The answer to that is sure. It is possible that the dog is alerting to burnt marijuana. But the other possibility, and the reason why it is a fair probability that evidence of a crime will be found in the entire vehicle, is that this case will also occur. It is possible, just as it's possible it's the same odor, it's possible that there is a different odor. What if, assume, there was cocaine in the vehicle as well that the officer was incapable of detecting? Does the fact that a person riding in a car smokes some marijuana in their vehicle, throws out the blunt or whatever object they're smoking, and gets rid of any shake left in the vehicle? Is the police now limited to a search of the passenger compartment and cannot get to the kilo or more of cocaine in the back of the car? That seems an absurd result. What about this case, the minor misdemeanor marijuana possession charge that maybe the police could pursue, even though there's a complete lack of prosecutable evidence in that case, for the burnt marijuana smell? Well, he says it was his friend, so who are the defendants in that case? What is the evidence the state would rely on in issuing that citation? You're riding in a vehicle that has the smell of burnt marijuana. What is the crime there, please? So we're conducting a passenger compartment search. Meanwhile, the defendants, armed with whatever decision this court would issue if it affirmed Mr. Ross's statement of law, would be entirely free to hide all of their drug evidence in the trunk, knowing that it was safe from any search, because if the police brought a dog to the scene, under Mr. Ross's rule, would be entirely unable to get into the trunk. Ross, therefore, seeks to use Ferris not as a shield to prevent unlawful searches into vehicles, but as a sword to arm drug traffickers with the ability to safely conceal their drugs in their trunk as long as they take the proper precautions. That's an absurd result and not what the Fourth Amendment is intended to protect. For those reasons, and strongly affirming precedent, the state would respectfully ask you to affirm the decision of the trial court in this regard and overrule the assignment of error. Are there any questions from the court before I pass my time?
I don't believe so.
Thank you very much, Your Honors.
Have 4 minutes.
I suppose I have new advice to be giving my clients about their smoking of marijuana in their cars. Those aren't the facts of this case. I understand that, that sounds good for the state to make those statements, but those aren't the facts of this case, that somebody can go around and smoke marijuana and, hey, you can smell the same. The point is, the officer has an extended period of time where he sits there and does nothing. He does not prosecute a search diligently. He doesn't do what, Rodriguez and these other cases say you're supposed to do, which is if you have reasonable articulable suspicion, act on it. Don't just keep it at the side of the road until you get something that isn't even going to confirm. That's the other issue, is that, well, it's a possibility that there could have been cocaine, heroin, all this. Yeah, okay, I suppose that's possible, but the officer is going to say with a reasonable degree of certainty he has no clue what the dog is smelling. The officer will even say, and he testified at at the hearing. I have dogs alert all the time that don't alert to anything. You know, there's no drugs found. I certainly do not believe that if this court did previously suggest that as long as it's a reasonable amount of time afterwards, maybe Rodriguez, to a certain extent, overrules the Valente decision that the prosecutor was talking about, because Rodriguez says you have to look at what the police actually do, not what they could have done. The Rodriguez case comes from Nebraska, and what the Supreme Court thought was ridiculous was this bonus time that the government was arguing. That was not the law of the land there in Nebraska. And what the court ultimately held was that absent reasonable suspicion, which the officer may have had, police extension of a traffic stop in order to conduct a dog sniff violates the Constitution's shield against unreasonable seizures. And further in the holding is, the critical question is not whether the dog sniff occurs before or after the officer issues a ticket. I know the prosecutor said that was the linchpin in that case, was they'd already issued the ticket, so that was why Rodriguez was different. Right in the holding, the syllabus rather, which includes the holding, says that's not the issue. It's whether conducting the sniff adds time to the stop. So.
But the prosecutor's saying that Rodriguez actually even remands it and says, is there an issue of reasonable suspicion to extend the time of the stop?
And there was nothing there in Rodriguez.
Well, but they remanded it for that issue. So they
Sure.
Obviously, if you're remanding it, you're saying this could extend the time for the stop.
Well, I just don't think it was a decision that was before the court. I think that the lower court had to address that. But I suppose in this case, what we have is, did the officer, waiting for this canine, extend the stop? I think that it did. I know that it did, because the officer says it was 7 to 8 minutes. He was done. And then in the 8th minute, 9th minute, 10th, 11, 12, 13, 14, 15, 16, 17, 18, 19, he's still waiting for an officer to show up. How long would it have taken him to search the interior compartment of the car, find evidence of, I believe the prosecutor even said, can't even prosecute, not even enough evidence to collect for prosecution, would have had to have sent Mr. Ross on his way. We're not talking about, hey, you see some cocaine, a bag of cocaine, but you only smell marijuana. I'm talking about maybe, I don't know. I remember the last time this issue came up, I was a law clerk at a law firm in Cleveland, second year of law school. This is the second
And we're
time.
going to have to leave it at that because you're out of time. We won't know what happened when you're a law clerk.
Very good.
Thank you. We'll take the matter under advisement, issue a written opinion, and we'll also release it on our website. Thank you so much, gentlemen.
Thank you, Your Honor.